house.
Well,
My assistant's son used my car, took my backpack out as he was shoving people around.
oh, great.
So I'm waiting for him to bring
Oh,
my
that'll be helpful.
stuff. Yeah. Oh, great.
Oh, yeah.
Great. There we go.
I got my eye on all of you.
Yeah. You know, I need is one eye for this class.
Yeah, we're not quite ready to go. We still got one more student.
I know.
So, did either of you, Rams fans, see Jared Goff go to Ventura College in disguise?
No.
I did not. Oh my goodness. He went to Ventura College in disguise, had long brown hair on. They doctored him up with some fake tattoos, put a mole on his face, and they referred to him as Dre Folk. And the coach told the Ventura team that this was the transfer. He was trying out the quarterback, and it was the funniest thing you've ever seen. He was out there, and the first several passes were awful. And the team was giving him a hard time. He had these long bangs in his face, and he kept making excuses. Well, normally my bangs go to the right side, so it's really funny. And he walks up to the starting quarterback and says, "So are you the punter?" The guy's telling the quarterback. I said, "Yeah, okay. What was your record last year?"
Victor.
Tells me. Yes, that's why I'm here. He starts throwing 80-yard passes, and all these young kids are, "Oh my gosh!" And he's dropping back, and he's hitting guys on slants and cutting cover two up. And the starting quarterback sits down. And it's like, I'm bad. My dreams of getting a Division I scholarship are over. That's the funniest thing. I thought.
Now, how'd the receivers do? I can only imagine.
A couple of the guys did pretty well once they realized that, but one guy said, I'm really fast, I'm really fast, I'm really fast. And Jerry said, "You're really fast, huh?" I said, "Yeah." "Okay, we'll see." He's just supposed to stay 80 yards. Kids just it's really funny.
I'll have to look that up.
Yeah, it's really funny.
See what's going on.
Good spirit to do something like that.
Oh, yeah.
A bunch of kids.
Hi, baby. I'm a new
How's it going?
Huh? I'm the new kidney class.
Oh, yeah, okay, good. I think you use an extra person. Jeez. Mars.
All right, so we're fortunate enough to have Professor Nolan with us. Tonight we're going to be talking about combining corporations, tender offers, and how you might defend the control of your corporation if you want to fight off somebody. First, you all have a copy of an article from the Federal Judicial Center that exists to educate the federal judiciary. So I figured if it was good enough for them, it was good enough for us. It summarizes a whole bunch of things. Well, first of all, it came out last year, so it's pretty current. And it summarizes a whole bunch of things that we talked about, but in the litigation context. So it talks about, if you look at the table of contents, actions under the securities laws, particular ones. We're going to talk about the Williams Act because it relates to tender offers, short swing profits, etc., and can be cases and whatnot. So proxy litigation, and gives an overview about how corporate litigation goes generally, including class actions. So I thought it would be useful for this case, for this class, but also just in general about corporate litigation. All right. So tonight we're not going to cover all of Chapter 15, not even close, because it's a ridiculously long chapter. But we are going to talk about the stuff at the very start of the chapter. Okay, a sale of substantially all of the assets of a corporation. Hollinger versus Hollinger, which ironically has got to do with something called the Telegraph Group, and not anything to do with Hollinger. Talks about when do the shareholders have a right to vote, right? So let's talk about that. Did anybody read that case closely? No. Okay. Hollander versus Hollinger is right at the start of the chapter.
I apologize, I read this a week ago.
That's okay.
Look at my notes here.
Okay, so a company called Hollinger Inc., and you're still waiting.
I'm still waiting,
It's
yeah.
backpack, yeah.
So it's on the way?
She said.
Okay. So a company called Hollander Inc. was seeking a preliminary injunction preventing an entity called Hollinger International Inc. from selling the Telegraph Group. Telegraph Group publishes well-known newspaper, both in terms of circulation and respect in the United Kingdom. Key question is whether the corporation and other shareholders must be provided with the opportunity to vote on the sale because that sale involves substantially all of the assets of the corporation. Under Delaware Corporations Code Section 271. There was a long auction process. The international company put up to bid all of the assets. They were shopped to a lot of different bidders. And as a practical matter, the only vote that would count was the company that they identified as Inc. Why is that? Because most of the voting power, even though it only owned 18% of the stock, most of the voting power was through a Class B type of stock. They had 68% of the voting power. So one wonders, why are we litigating about this? Because if you have to put it to a vote of the shareholders, guess what? There's only one shareholder's vote that counts anyway, right? In any event, it did get litigated, and International argues that the sale of the Telegraph Group doesn't involve 271 at all, because they're only buying assets that are in the United Kingdom and not by the international company. And the court discusses that and how that applies, and the chancellor who wrote this opinion finds that parties are taking starkly different legal conclusions based on the same facts. International contends that 271 doesn't apply, doesn't contemplate ignoring the separate existence of subsidiary corporations unless you can pierce the corporate veil. If International is right, then 271's vote requirement will be rendered largely hortatory, right? In other words, it doesn't matter, reduced to an easily sidestepped gesture, but little more toward the idea that transactions that dispose of substantially all of the corporation's value need shareholders' assent to become effective. And they give an example about that, assuming the board decided to sell all of International's groups, and they could just form subsidiaries, and even if they sold everything, it wouldn't matter because they weren't selling it directly, but through the subsidiary. Then the chancellor said, okay, the facts here seem to indicate maybe a line drawing point. When an asset sale by a wholly owned subsidiary is to be consummated by contract in which the parent merely guarantees the performance of the subsidiary that is disposing of all its assets, and in which the parent is liable for any breach, then the direct act of the parent's board can, without a stretch, be viewed as selling the assets itself. So in other words, you don't have to pierce the corporate veil, but if the parent corporation is going to be on the hook, then we're going to treat it as if the parent was selling the assets itself. The parent's promising to dispose of everything. The parent is on the hook if something goes wrong. And the chancellor says that if 271 applies to such a contract, it would comprise substantially all the parent's assets and wouldn't be an irrational implementation of the legislative intent. But the chancellor says, I don't have to do that. I don't have to reach that conclusion because I can resolve this motion for an injunction without rendering any definitive. Why he goes through all this discussion, who knows? But he says, I don't have to do that. I don't even have to reach the issue. As a matter of economic substance, does the Telegraph Group comprise substantially all of international assets? Okay. So let's see if it does. Section 271 authorizes the board to sell all or substantially all of the assets, including goodwill, only with the approval of a shareholder vote. So, he says, we're going to start with the words of the statute itself. A fair and succinct equivalent to the term substantially all would be essentially everything. Words of this kind he quotes the Supreme Court. Supreme Court has long held the determination of whether there has been a sale of substantially all the assets to trigger 271 depends on a particular qualitative and quantitative characteristics of the transaction at hand. In other words, substantially all, we're going to construe substantially all on whether a transaction involves the sale of assets quantitatively vital to the operation of the corporation and is out of the ordinary and ordinary operation, ordinary and substantially affects the existence and purpose of the corporation. Okay, so did that happen here? He concludes that it didn't. Right? It's not he found that it is not quantitatively vital within the meaning of a case called Kimball. Why is that? Because international will retain economic vitality even after a sale of the Telegraph because it's retaining other significant assets, one of which is the Chicago Group, which owned various newspapers and has a strong record of past profitability expectations of healthy growth. So, even though they're basically selling their most important asset, they're not selling all of them, and they'll still have some other assets, and so the statute wasn't implicated. So, what if? How would that statute apply if they basically sold off their assets piece by piece, right? Mm-hmm. Oh, sorry. They basically sold all their assets off piece by piece, right? So they just break it up into, they slice the salami, break it up into little pieces, and they sell first the Telegraph, and then they sell the newspaper in Jerusalem, and then they sell the newspaper in New York, and then you just do piece by piece. At what point do the shareholders get to finally vote? When they're selling the last piece? This analysis really, it makes sense on one level, and it doesn't really make sense on another because it sort of gives you, if you're the parent corporation, you're like, okay, I know how to do this. I'm not going to sell everything all at once. Mm-hmm. I'm just going to sell it piece by piece.
Right, because wouldn't it all hinge upon the second element? Changes when it starts to change the nature of the corporation.
And well, you've still got substantial assets, right? You still got newspapers. Mm-hmm. You just sold. So an example that the professors who wrote the book used was: suppose you were in the department store business, and you had a big department store in downtown Chicago, and you decided, you know what, the department store business sucks. We're going to sell everything. Sell it. We're going to sell out. Have a fire sale or going out of business sale. Sell all the assets in the department store. Sell the property, and we're going to have a bunch of money, and then we're going to invest it in something else. Okay, would that be a sale of substantially all the assets? It sort of looks like it.
Could be.
But would it matter what the purpose was? Suppose you were going to sell all that stuff, buy or develop a new mall out in the suburbs where the land was cheaper and you were closer to your customer base, and you built another among things.
Where you're expanding your online retail and you're building warehouses.
Yeah, exactly. Yeah. So does the purpose of what you're doing?
Right.
So you can see, well, if you apply this test, it's like, well, on the one hand, yeah, they're selling all the stuff, right? Mm-hmm. But if they're selling all the stuff to still stay in the retail business, then have they really changed the nature of their business? And should the shareholders get to vote? If they're selling all the stuff and just distributing all the profit or all the assets, that's probably a yes. The shareholders get to vote. But other than that, it gets real sticky to figure out when do the shareholders get to
So
vote.
how do you delineate on that line, Judge? I mean, what is the two elements are very clear, but I guess in practical application of those elements in an ever-changing business environment, today's ever-changing business environment, what, I don't know how to ask the question I'm trying to ask. A simple question is what really is the maker of the argument attempting to persuade the court to see that it doesn't, that either isn't in plain view or is
My briefs are on here and the
Un-
exam stuff causes it to turn off and
No,
on.
I was able to access the cloud, so I apologize. I guess, so if you're the maker of the argument, what is it you're attempting to convey to really highlight? What's that bright line on either?
Well, if you're the shareholder and you don't like what what management, the board is doing, then you're trying to disrupt things as best you can. And it may be you may not disagree with the overall point, like, yeah, our business is going downhill and we really do need to change it drastically. But it may be that you're going to realize a whole bunch of capital gains, or there may be tax consequences to you, and you don't want the transaction to be sell everything and distribute it, right?
Gotcha. So you're trying to make the most persuasive argument.
Well, if you're the shareholder or the shareholders, you're always going to want to vote, right?
Mm-hmm.
So you're always looking for a way to characterize it as they're getting rid of the whole company.
Mm-hmm.
And they're like there was a story about about an American airman that was shot down during World War II. He's in a prisoner of war camp, and he's badly injured, and so they amputate like part of one leg, then the rest of one leg, part of another leg, part of his arm, and the Germans were like, hey, we're not going to let you escape piece by piece like that. Right? So it's sort of like that with what by implication the strategy would do if you're a parent corporation, just sell it piece by piece. And I think if you're the court on that, you're like, well, what's the plan, right?
Mm-hmm.
If the plan
What's
really,
the plan?
if
Yeah.
the plan, what's the overall plan?
Mm-hmm.
And can the board credibly say our plan is not to sell everything piece by piece, but we're only going to sell this piece and then we're going to keep going? Okay.
Right.
And you've got time to do discovery, right?
Mm-hmm.
Presumably you could get a temporary injunction stalling the sale while you did the discovery, maybe some, quick discovery to figure out, is there a plan?
Sure.
What is the plan? And here, on the one hand, it sounds like the plan is to sell everything off, but they pretty clearly, as the chancellor describes it, at this point anyway, all they're doing is selling that London paper. Yeah, and they're keeping the rest.
Yeah.
So anyway, on the surface, it sounds like, yeah, the shareholders have the right to vote. But it quickly becomes, how do you figure out whether it's the kind of transaction that the shareholders would have the right to vote on? We did have a note that talked about the history of the right to vote. It transitions into the appraisal remedy, but on page 867, prior to the mid-19th century, so middle of the 1800s, any change in the rights of shareholders, whether by amendment of the articles, merger, or sale of all the assets, required approval of not just the majority, all the shareholders. So you can imagine that's totally not working in the 20th or 21st century. the prevailing view was shareholders had a vested right protected by the Constitution, so that if you're going to relax that unanimity requirement, then you need to protect them some other way. Pennsylvania said, okay, here's what we'll do. If you don't agree to the sale, we'll give you the right of appraisal for your shares. And this caught on. It's now a law pretty much everywhere. But note how it started. It started because shareholders had the right to vote, and not just vote, but veto any transaction that would merge or even amend the articles of corporation or sell all the assets. Different states are more protective of rights than other states. Some states allow for amendments to the article, can vote on amendments to the articles. They're not going to, if they affect the rights of shareholders, if they sell all or substantially all, they get to vote. Delaware has a stricter approach. Their appraisal statute only applies to a merger or a consolidation, basically the same thing, right? So if you're going to sell all the assets, then shareholders don't get to vote. Well, why the heck not?
So obviously shareholders are supposed to vote when you liquidate the assets.
Yes.
Well, depending on the statute.
But if even though there is number of assets comprising substantial or put together, but not necessarily alone, they can actually liquidate one at a time and get away with it.
Exactly.
Wow, okay.
Exactly. And that's why I was saying what you probably end up happening is if you're the shareholder and you think that's what's going on, you ask the court to temporarily enjoin it while you do some discovery and see if there is that plan. You know, is the plan really to slice the salami and sell all the slices, or is it just to get rid of a piece, right? And then again, you might find, as in the illustration we were talking about, maybe the plan is to get rid of the physical store and be Amazon, right?
I think that is the $1 million question. What's the plan?
Yeah.
Getting at the heart of the intent. Yeah.
But so I guess the point is, or my point is, it sounds like a bright line rule, and it gets mushy really fast.
Very quick.
Okay, so the appraisal remedy depends on the language of the particular statute. Some statutes are more favorable than others for shareholders. And then what do? You compare the price immediately before the transaction became known with, and that's the goal, is to figure out what was it worth right before the public found out about the transaction, and that's the price you get for your shares. Although it's often referred to as dissenter's rights, you don't actually have to vote against the proposal to be protected. All you have to do is not vote for it. Sounds like it's the same thing, but it's not. And there are a whole bunch of procedural steps under any of the statutes. Delaware, for example, provides that before you get a vote on a merger or consolidation, because remember, theirs is more restricted. You only get it if it's a merger or consolidation. Shareholder has to make a written demand for an appraisal and a rather short period of time, 120 days after the completion, in which the appraisal has to be commenced. And different statutes have different procedures. We also have a note on whether that's the exclusive remedy, right? Is your remedy, if you're one of those shareholders that's not agreeing to the proposal, do you have another remedy you could pursue, like rescission or seeking an injunction? And again, it depends on the state. There's a lot of variation about that. Most jurisdictions require that availability of appraisal rights normally does preclude a shareholder from seeking to recover on an allegation that the transaction doesn't provide fair compensation. If that's all you're, thank you, sir. If that's all you're claiming, then that is your exclusive remedy. If you've got some other claim, then it's not, and you can seek rescission or an injunction or something else. So let's see. And the note talks about Delaware and how how its courts are especially reluctant to make appraisal rights the exclusive remedy if there's an allegation that the directors are engaging in self-dealing, like they're selling the assets, but they're also buying the assets, right?
Selling it to themselves.
Yeah, exactly. And remember, we talked about, say, self-dealing and rights and obligations of insiders and when you can be liable for that, and how you, if you are on both sides of the transaction, you lose the protection of the business judgment. Okay. We are not going to spend time talking about tax aspects. I just recognize there's also tax aspects.
This is a real question. Next three is 15%.
You're supposed to know all this in detail for the more, I suppose, right?
There is there's something that's called a statutory merger. If you're not a lawyer, you think of a merger as pretty much businesses getting together.
Right.
But a merger is specifically one company, two companies merging, one surviving, one disappearing. There's also a consolidation where they merge and there's a new entity that results. That's pretty rare, although it does exist. So typically with a merger, two companies come together, one disappears, one survives, and the one that survives ends up paying by stock or cash or whatever compensation to the shareholders of the one that disappears. Different states have different requirements, but in general, the parties reach some sort of tentative agreement. It's embodied in maybe a letter of intent, and then it has to be approved by the board and the shareholders, of both corporations. Both of the corporations, the board would approve it, put it out to vote for the shareholders would approve it, and then articles would be amended, and perhaps new stock would be issued, or maybe it's just stock in the surviving corporation that exists. There are what are called short form and small scale mergers, and they're more simple or less money involved, and just recognize there are some special rules for those. Okay. All right. Okay, let's talk about Ferris versus Glenn Alden. It's on page 878.
This is a statutory merger. No, that was the de facto merger, right?
Yeah.
By contract versus.
Which case?
Ferris versus Glenn Alden, page 878.
Pennsylvania case?
Yeah.
Court says we're not talking about the doctrine of independent legal significance. We're going to look at the substance of what the transaction is, not its form. Well, let's go over this. Okay, so the court is looking at whether as a result of a reorganization agreement executed by the officers of Glen Alden and List Industries, and approved by the shareholders of Glen Alden, the rights and remedies of dissenting shareholders accrue to the plaintiff. Glen Alden is a Pennsylvania corporation. It's in mining business. In recent years, it's lost a lot of revenue, and coal operations have resulted in tax loss carryovers of $14 million. That's a lot of tax losses, especially back in the 50s. List, a Delaware holding company that owned motion picture theaters, textile components, and real estate, and some oil and gas. Purchased through a wholly owned subsidiary 38.5% of Glen Alden's outstanding stock. This acquisition enabled List to place 3 of its directors on the board. In March of 1958, they entered into a reorganization agreement subject to shareholder approval. And here's what they were going to do. Glen Alden would acquire all the assets of List, except a small amount of cash reserved for the payment of List expenses. That included over $8 million in cash held chiefly in treasuries of List wholly owned subsidiaries. Glen Alden would then issue new stock to List. So this sounds like Glen Alden is taking over List, right? But that's really not what's happening. So List in turn was to distribute stock to its shareholders at a certain ratio. And in order to accomplish the distribution, Glen Alden was to increase the number of its stock from 2.5 million to 7.5 million. And then Glen Alden would assume all List liabilities, including a $5 million note that was being used to do what? To purchase Glen Alden stock the year before. Okay? And then Glen Alden would change its name to List All. And both corporations become directors, and then List would be dissolved, and List All would carry on the business. So they notified shareholders with a proxy statement what they were going to do. And at the shareholders meeting, a shareholder of Glen Alden filed a complaint against the corporation seeking to enjoin them from carrying out the agreement. And the complaint alleged that it didn't conform to the requirements of Pennsylvania law. In 3 respects, it didn't give notice to the shareholders that the true intent was to effect a merger from Glen Alden and List. It failed to give notice to the shareholders of the right to dissent, and it didn't contain copies of the text certain guys. It's a kind of a technical requirement. The defendant said, there were many material allegations of fact in the complaint, but denying that they gave rise to a cause of action because the transaction was a purchase of corporate assets as to which shareholders had no right of dissent or appraisal. Okay, so they're saying this isn't a merger, this is a purchase of assets, right? Court says it was a de facto merger, and therefore you're supposed to comply with the provisions. The court kind of wistfully says, when use of the corporate form first became widespread, it was relatively easy to define a merger or sale of assets and to call it one or another. But because people wanted to try to avoid the impact of the adverse and to gain the benefits of the favorable government regulations, particularly tax laws, they came up with new techniques, and lawyers and accountants got busy. And now it's no longer helpful to consider an individual transaction in the abstract and solely by reference to various elements to determine whether it's a merger or sale. In other words, now it's not as easy as it used to be to figure it out. Instead, what we're going to do is we're going to look at the whole agreement and the consequences of the transaction and the purposes of the corporation law to figure out what it is. Okay? And then they go through and try to figure it out. Does the combination outlined in the reorganization agreement so fundamentally change the corporate character of Glen Alden and the interests of the plaintiff as a shareholder that to refuse him the rights and remedies of a dissenting shareholder would force him to give up his stock in one against his will accept shares in the other? If so, then it's a merger even though it's called a sale of assets, right? If the reorganization occurred, plaintiff would end up that the last Alden or the list Alden resulting from the amalgamation would now be a quite different corporation than the Glen Alden, in which he's currently a shareholder. It wouldn't be a coal mining company. It would be transformed into a diversified holding company, which looks an awful lot like List, right? Motion pictures, textile companies, etc. And he'd be a member of a company with assets of 169 million and long-term debt of 38 million instead of a company 1/2 that size and 1/7 of that debt. So kind of sympathetic to the plaintiff, right? And they point out the most important, perhaps the most important consequence if the plaintiff was denied to have his shares redeemed at their fair value would be the serious financial loss suffered upon the consummation of the agreement. Present book value of the stock is $38 a share. After the combination, it would be worth only $21 a share. But the shareholders of List, who presently hold stock with a total book value of $33,750,000 a share, would receive stock with a book value of $76 million or $21 a share. Wow. So this is like totally screwing over the Glen Alden shareholder, right? You can see why the guy was upset. The court held it may well be that if the proposed combination is allowed to take place without dissent, plaintiff would have his stock in Glen Alden taken away and the stock of a new company thrust on him in its place. So, but the defendants contend the amendments to the statute entitle them to win, and court analyzes their statutes, and finally concludes that even if the combination provided for in the reorganization agreement is a sale of assets, it would avail the defendants nothing, will not blind our eyes to the realities of the transaction. So basically this is, we recognize that just because you call a thing a sale of assets and just because you structure it to make it look like assets are going to be sold, that doesn't make it a sale of assets. And so the court found that this reorganization, even though it was a contract and not following the statutory merger procedure, was a merger within the meaning of the Pennsylvania Code sections, and the shareholders should have been notified given their statutory rights of dissent and appraisal, and the failure to take these steps makes the shareholder approval of the agreement invalid, and therefore the lower court was right to issue the injunction. So on the one hand, hey, what's so awful about owning shares in a company that's bigger and more diverse? Well, what's different is that your stock's worth less, right? Mm-hmm. And which sort of gives you the impression that maybe it wasn't really at arm's length, or maybe it was deliberately structured to disadvantage the Glen Alden shareholders. And let's see. Footnote 1, List borrowed a whole bunch of the money to buy a stake. It then had 3 of the people on the board. 3 out of how many, we don't know. Mm-hmm. Then the Glen Alden assets can be used to satisfy the loan that was used to buy the Glen Alden stock. Mm-hmm. So List appears to have twisted the transaction around to make Glen Alden look like the purchaser. This is a good case to say Glen Alden shareholders needed some mechanism for an independent determination of the value of their shares. So, and then here we come with the appraisal remedy. Okay. And
We thought we were gonna have to
This is the third one in
Do we have
24
to-
hours.
we have to drop and cover.
No, it's just the short ones, don't be. But
It could be the little one before the big one.
Right, exactly. This is the third one. At least we have.
Okay, so this case tells us you got to look at the substance of the transaction, and not what the documents or what the parties call it. Okay. Clearly, one reason they did it was to avoid appraisal rights. Second reason might have been to keep Glen Alden's tax loss carryover alive, right? Because remember, they had 14 million in tax loss carryovers. If you can keep that, that's worth a lot. And a third reason, in answer to the question of Mr. Justice Bellis, so why List did not purchase the assets of Glen Alden, Mr. Littleton answered that the 1% Pennsylvania realty tax on the transfer of the coal mining holdings would make the sale prohibitive. In other words, we're trying to avoid taxes, both by keeping the tax loss carryover and by avoiding Pennsylvania state tax. And for what it's worth, after the lawsuit, the corporations were combined pursuant to a statutory merger, probably for some of the reasons just given. Glen Alden was a surviving corporation. The List shareholders recovered 1 share for 1 share of List stock, and the Glen Alden shareholders ended up with 5 shares for each 4 that they previously held. And interestingly enough, the Pennsylvania statute now expressly rejects the reasoning in Ferris that dissenters' rights arise in the acquiring company by virtue of the fact the acquisition had been structured so that the mouse swallows the lion. So in the end, what happened? Now mice can swallow lions.
No, right? That's nice.
Right. Because when it comes to writing laws, you can always buy off the legislature. Okay. All right. There's another section that we'll cover on freeze-outs. A freeze-out is a corporate transaction whose principal purpose is to reconstitute the corporation's ownership by involuntarily eliminating from the equity interest of the minority shareholders. Right? Mm-hmm. Okay. So we are tired of you minority shareholders. We're going to get rid of you. Mm-hmm. And the note on page 888 talks about different ways you can do that. Okay. A dissolution. Assume that S, who may be an individual group corporation, owns 70% of C and wishes to eliminate the other 30%, right? Mm-hmm. And a dissolution freeze out, S causes C to dissolve under a plan of dissolution, which provides that C's assets will be distributed to S or to an entity S controls, while cash or notes will be distributed to the minority shareholders. Mm-hmm. Okay? We'll get the assets, we'll give you the cash, and then you're gone, and we still have the assets, right? Mm-hmm. This technique has been held illegal in a number of cases, most of which stress that plan of dissolution violates the corporate norm of equal treatment among all shareholders of the same class. Okay? Another way to try this is a sale of assets, right? The controlling shareholder, corporation's controlling shareholder organizes a new corporation, all of whose stock the controlling shareholder owns. S then causes, so that would be the new corporation, the controlling shareholder then causes the corporation to sell its assets to that new corporation for cash or notes. So the result is the controlling shareholders owns all the corporation's business through the new corporation, while the equity interest of the minority shareholders is basically terminated, and then C is dissolved, although you don't have to dissolve it, and that's been disapproved in some cases too. Another technique, debt or redeemable preferred mergers. A debt or redeemable preferred merger begins like a sale of assets. Controlling shareholder forms a new corporation. And, however, instead of causing the corporation to sell its assets or transfer its assets to the new corporation, you merge the existing corporation into the new corporation. And instead of issuing common stock, the new corporation either issues short-term debt or redeemable preferred stock. Thus, the interest of the minority shareholders in the new corporation either terminates automatically after a period of years in the case of the debt, or is terminable by T's election in the case of the redeemable preferred stock. Cash out mergers, most modern freeze outs commonly employ another technique. Most states allow the survivor in any type of merger to issue cash as well, or instead of stock. Why not? Cash is good, right? So this opened the doors to a cash merger, which resembled debt or redeemable stock mergers, except that the survivor issues cash rather than stock or debt. Under this technique, the freeze-out possibilities of the short-form merger, remember we talked about those simple merger techniques, are extended in cases where the parent doesn't own the percentage of stock required for a short-form merger. So what do? You set up a new corporation and you merge it with your old corporation, but instead of issuing stock or securities or whatever, you just pay the shareholders, and then you've got the business without the shareholders. And then there's one other strategy is dividing the share stock split, right, or reverse stock split. So instead of having more shares outstanding, you do a reverse split, have fewer shares outstanding. So a 1-for-25 split will result in the holder of 500 shares now holding only 20. How can that result in a freeze out? Because everybody owns, less shares now. If it can result in a freeze out if the resolution approving the split provides that the corporation has a right to purchase the shares of any holder of less than a certain amount. Oops, what happens? You used to have 500, now you have 25. The agreement says you can buy the 20, anybody who's got less than 100, great, now we buy the minority and boom, they're gone. There are lots of different ways to try this. Some of them clearly aren't legal, but some of them are. Okay. We're still in section 1 of this chapter, can you believe that? I think we're soon to get out of this. Let's take a look at the Glassman versus Unical Exploration Corp case. It's from Delaware. What are the fiduciary duties owed by a parent to the subsidiary's minority shareholders in the context of a short-form merger? Trying to reconcile a fiduciary's seemingly absolute duty to establish the entire fairness of any self-dealing transaction with the less demanding requirements of a short-form merger. Okay, the statute authorizes the elimination of minority shareholders by a summary process that doesn't involve the fair dealing component. Indeed, the statute doesn't contemplate dealing at all. Thus, the parent corporation cannot satisfy the entire fairness standard if it follows the short-form merger, doesn't do anything else. So, Unical, remember big oil company in California, right, addressed this dilemma by establishing a special negotiating committee and engaging in a process that it believed would pass muster. Okay, so what did they do? Unical owned 99% of the stock of Unical Exploration. Boards of each company appointed special committees to consider a possible merger, and the exploration company retained legal advisors, financial advisors. They met several times, agreed to a merger where just over half of Unical shares would be issued for each expiration year. Announced the agreement, carried it out as a short form merger. Plaintiffs filed a class action on behalf of the minority shareholders. Remember, it's only 4%.
Right.
That the merger violated the entire fairness requirement. Court talks about what the short form merger statute was supposed to do and how it was expanded to cover parent subsidiary mergers where the parent owns at least 90%. And it made it possible for the first time and only in a short form merger to pay the minority cash, thereby eliminating their ownership interest. And so the court says we have to decide whether a minority stockholder may challenge a short form merger by seeking an equitable relief through the entire fairness claim. A parent and its directors undertaking a short form merger are self-dealing fiduciaries, right, because they're on both sides of the transaction, who should be required to establish entire fairness. The problem is that the statute authorizes a summary procedure that's inconsistent with any reasonable notion of fair dealing. So they're following the letter of the law, but they're also screwing over the minority shareholders. So the court finds that absent fraud or illegality, appraisal is the exclusive remedy available to minority shareholders who rejects the short form merger. In other words, the way we're going to satisfy that entire fairness is to give you an appraisal remedy, and that's it.
It doesn't have to be fair.
Pardon me?
It does not have to be fair.
Well, the way we try to reconcile you want to file a short form merger, which doesn't require that you satisfy the entire fairness doctrine, and the goal of the entire fairness doctrine, we're going to say, here's how we do it. You have appraisal rights so that you'll get paid a fair amount, but you'll also be cashed out, right? So it appears that the court thinks that meets the goal of the entire fairness doctrine. The determination of fair value must be based on all relevant factors, right, including damages and elements of future value where appropriate. So if the merger was timed to take advantage of a depressed market or at a low point in the company's cyclical earnings or to precede an anticipated positive development, right, all of these things that would tend to depress the amount of money that you get for the minority shareholders and deny them really the fair value, right. Well, then the appraised value may have to be adjusted to account for all of that. Those kind of things are raised in entire fairness claims, and the court acknowledges, and we've held that claims for unfair dealing cannot be litigated in an appraisal. But our prior holdings simply explain that equitable claims may not be engrafted onto a appraisal proceeding. Stockholders may not receive rescissionary relief and appraisal. Those decisions should not be read to restrict the elements of value of the property. So they reconcile this by saying, we didn't mean by what we held before to say that you couldn't consider everything when you're trying to figure out how much the shares are really worth, okay? They acknowledge you don't have to show the entire fairness, right? But you've still got the duty of full disclosure. So you have to tell the minority shareholders everything about the transaction. And where the only choice is whether to accept the merger or seek an appraisal, they must be given all the information that they need to make that decision. And the Delaware Supreme Court says the Chancery Court carefully considered the disclosure claims and applied settle on rejecting them, and so they affirmed that. This is kind of interesting because it's trying to reconcile two things that conflict. One is we're trying to protect minority shareholders by the entire fairness doctrine, right? That they transact that if you're self-dealing, you have to show that the transaction overall is fair to the minority shareholders. But we also were trying to comply with the literal words of the statute, because if you're a Unical, you're like, hey man,
You follow.
we did exactly what the short form merger statute said. The legislature wrote the law for a reason. We followed it, and that's how the Delaware Supreme Court sorted it out, said, okay, you're right. But you get the appraisal remedy, that's your exclusive remedy, but we're gonna allow the court to consider everything and require disclosure of everything to the minority shareholders so they can litigate and get a fair result. All right. Time is it? Been having so much fun.
Lots of fun.
We're actually flying through this.
What's that?
I said we're actually flying through this quite well.
Yeah, and by the way, you still don't have your stuff.
I know, I was looking access the cloud.
Oh, that's
Thank
good.
goodness. I just can't. I'm struggling with my head.
It's too small.
I know.
Can you read it? Yeah.
Yeah, but I mean, that.
Or you know what, also, you wanna borrow my book, cause I have it online. Wanna do that too?
I got my briefs.
Oh, okay, whatever you want, or I'll just give it here, if you wanna, yeah.
Judge talks about the notes.
Okay, so we'll move to section 2 briefly. We've come up with some rather colorful terms in connection with tender offers. Tender offers are where you offer a certain price to buy. We'll buy, 10 million shares at, and here's the price we're offering. Anybody wants to sell to us, we'll buy. Okay, so tender offer. A few of the terms are listed here. A rater. A rater is a person, could be a corporation, doesn't have to be, that makes a tender offer. As the note says, the term is invidious. I mean, it sort of sounds bad, right? Better term would probably be bidder, but in any event, rater is the common one. Target's the corporation that you're trying to buy shares in. A white knight. White knight is often the management of a target. Management of a target is like, oh, we're not going to be able to be independent, but we sure don't want to sell to Raider, so someone else can come in and help us sell the corporation, but they're going to them. So this would be a white knight, right? Which is pretty much anybody other than the original bidder. A lockup is a device that's designed to protect one bidder, usually a friendly one or a white knight, against competition for other bidders who are considered less friendly. The favored bidder is given an option to acquire selected assets or given an amount of shares of the target at favorable prices under certain conditions, and those conditions usually involve they either defeat they defeat the other bidder to acquire the corporation, or the occurrence of events that would make the defeat likely. So we're going to give advantages to the company we want to buy our shares, so it makes it hard for anybody else to do it. Okay. Crown jewels. What are crown jewels? To defeat or discourage a takeover by somebody that you don't want, target's management may sell or give to a white knight a lockup option that covers the most desirable assets, right? The things that the raider really wants. Fair price provisions. A fair price provision requires that a supermajority, typically 80% of the voting power of the corporation, must approve any merger with an acquirer who owns the specified interest in the corporation, usually 20%. Supermajority vote is not required under certain conditions. Most notably, if the transaction is approved by a majority of those directors who are not affiliated with their acquirer and who were directors at the time that the acquirer reached the specified level of ownership. So what are we doing? We're trying to make it impossible for the company we don't like to actually buy up or accomplish the transaction, right? Fair price provision discourages purchasers whose objective is to seek control at a relatively cheap price and discourages accumulation of large blocks because it reduces the options that the acquirer has got. Management buyout. Management buyout is an acquisition for cash or non-convertible senior securities of a public corporation by a new corporation in which members of the former management have a significant stake. Leverage. It's just the use of debt, so you like a lever to have more return on equity. It also means that you can get wiped out faster, right? Because if you borrow 95% and only put 5% of your money in, Well, sure, if the stock price doubles, guess what? You paid 5%, you get like 1,000% return. My math sucked, but you get the point. But also, if the price goes down even a little, you get wiped out. So leverage can be a good thing if it works, but it can also wipe you out. And if you wanted an example, ask people who were involved in Lehman Brothers 10 years ago, 9.5 years ago. Because no, Lehman Brothers, was that September?
September of
2008?
8.
Yeah, that was when they went, and they were like a going concern and doing well, and all of a sudden they weren't. And that weekend was really a fun
It was
weekend.
a bad weekend. I
Um,
was in China with the president of the U.S. Bank.
Were you really?
Watching that 9 hours ahead.
Oh, man.
It was awful.
The president of the U.S. Bank must have been a little freaked because there were a lot of financial institutions that could have easily gone under. I mean, they were having they were having those meetings at the New York Fed about who was going to buy whom for what, you know, and Goldman Sachs was like, went from being one of the most stable and whatever to, oh my God, we're going to go bankrupt. And it was like overnight. It's pretty nice.
Prevailing line was, oh, we're not involved in that. We're not involved in that. We're not involved in that. You just started watching McDonald's.
Yeah.
Fall.
Yeah.
We are involved.
And Merrill Lynch went from buying stuff to, oh dear God, the only way we're going to survive is if we get bought out. And so they ended up selling out at ridiculously low terms to Bank of America. But then Bank of America's management got thrown out because they had bought some mortgage origination company or bank that was held. Anyway, so leverage can be a good thing.
Who was that? Was that
Countrywide?
oh, yeah, I was going to say Countrywide.
I don't know. I can't remember. I used to pay attention to that. Okay, leverage buyout is a buyout that's highly leveraged. Duh. It's where the newly organized acquiring company has a very high amount of debt in relation to its equity. I think we talked about this earlier this year, but or earlier this semester. But if you have family members or you work for a company that's being taken over, either by a leverage buyout or something like that. If you're part of the control group that runs the new company and has an equity stake, it's going to be really exciting. It could be the best time of your career. It's going to be a very exciting period, and you could make lots of money. If you are not in the control group, get the hell out as soon as possible because it is going to suck. They're going to have to pay all that debt by cutting expenses massively. How do you cut expenses? You fire people and make the people that are left do more work for less. And reorganizing a company. Now, it may be that the company was poorly run and you can do that and make lots of money and whatever. But the goal is to buy it, reorganize it, restructure it, cut the expenses, and then either sell it, when it gets way more profitable, sell it to somebody else or sell off pieces or whatever in a relatively short period of time. 5 years, 7 years, something like that.
Or take the loss and write it off.
Yeah, well, yeah. But like I say, if you're part of that control group, life is great. It's really exciting because you stand to make tons of money. If you're not, it's going to be awful, and you got to get out of there. Get out of there immediately because it's not the same company that you knew, and it never will be, right? So words of advice from.
It's the absolute truth.
Yeah. So. Anyway, so those are the junk bonds are bonds that bear an unusually high rate of interest, and because they have a high default risk. One thing that's kind of interesting is generally the first thing that signals that the economy is going in the tank is junk bond yields start spiking, right? Because bond investors, especially investors in high yield bonds, are the most sensitive to, something could go wrong, or something is starting to go wrong, or we're a little worried that something might go wrong. And as a result, if you watch high yield bonds, if their prices start to tank, then it's something weird is going to happen, and it's probably not going to be good for the economy. and query whether we're getting close to that now, because this expansion has been in place for quite a while. The market seems to have discounted everything going really great, and there, are some things that may not go so really great. All right. No shop clauses. Board of corporation that enters into an agreement for a merger or another combination, whether with a white knight or whatever, might agree that it will recommend the combination to its shareholders and that it will not shop around for a better deal. And a standstill, a target may seek an accommodation with a shareholder who has acquired a big chunk of stock, under which the shareholder agrees to limit his stock purchases, right? Standstill. A typical standstill agreement, the shareholder makes use of various commitments. It won't increase above a certain thing for a period of time. It won't sell its shares without giving the corporation a right of first refusal, and it won't engage in a proxy contest, and so on and so on. Okay. All right. So the Williams Act, in the article that we've got, there is a good brief description of the Williams Act on page 29. And we'll go over that briefly. Williams Act, as tender offers became more popular and more subject to abuse, Congress added the Williams Act in 1968. And it's kind of, it's kind of early in the development of corporate raiders and corporate takeovers and whatever, because there was a lot more going on in the 80s than there was in the 60s. But obviously there was enough that businesses were worried about it. And so Congress amended sections 13 and 14 of the Securities Exchange Act. Before the act, a cash tender offer was an effective way to avoid the act's usual requirements for mergers, which required a shareholder vote, or included a shareholder vote requirement. Williams Act is neutral. It doesn't really take a position on whether things are mergers or cash tender offers are good or bad, but it adds disclosure requirements. So you can't secretly go around amassing a bunch of stock. So it's not intended to protect management. Suits are usually brought not by management, but by the target company on behalf of its shareholders, saying, hey, we're trying to protect our shareholders. What they may be trying to do is protect themselves. But anyway, two different types of claims under the Williams Act. First is under Section 13D, requires anyone who's acquiring a beneficial ownership of more than 5% of certain securities, typically it's an ownership interest in a publicly traded company, to file with the SEC, hey, we are acquiring more than 5%, and send a schedule to the issuer, the company that you're acquiring the stock in, with certain information. Okay, it's sort of like an early warning to investors and company management that a takeover attempt may be underway, right? Section 13D suits allege the disclosure disclosure information provided is false, misleading, otherwise defective. In other words, yeah, you made the disclosure, but you didn't tell us everything you were supposed to, or you lied, or whatever. There's no reliance on materiality requirements. In other words, if you're caught not disclosing something or giving a false statement, you're liable. As the article says, although purportedly Section 13D claims are brought with the shareholders' interest in mind, usually it's the managers who might get kicked out or don't like what's going on that will bring that suit to try to stall or block a tender offer, regardless of whether they would benefit the shareholders. Often 13D claims request injunctive relief to try to stop the person accumulating the stock from doing so. And this article does talk about TROs and preliminary injunctions. Supreme Court has made it clear you got to have more than just a technical violation to get an injunction. And so you need to look out for the policy concerns of the Williams Act. And you should consider whether additional disclosure that complies with Section 13 requirements might be sufficient to fix whatever problem we've got. And notice, as the article points out, Second Circuit, New York, where a lot of cases arise, have been really open to the option of just requiring additional disclosure. Second part of Williams Act litigation, 14D, Section 14D prohibits anyone from making a tender offer that would result in owning more than 5%. Okay, so what's the difference with 13D? 13D, you've acquired more than 5%. 14D, you're making an offer to acquire more than 5%. Okay? So if you're going to make that offer, you haven't acquired the shares yet. If you're going to make that tender offer, we'll buy shares from anybody at this price. You got to file notice of that with the SEC and file a statement with the company that you're buying the shares under. And it requires some things about tender offers and sets some time limits about withdrawing them, so you can't just like yank the carpet out from under everybody. Interestingly enough, the statute doesn't define what a tender offer is. The SEC has its list of like 8 factors. The courts generally haven't said that's the list, and those are the 8 important things. Courts have been more like we know it when we see it. And again, typically actions under Section 14D are brought by the target company, alleging that the company that's seeking to acquire it has made a tender offer without making the appropriate filings, or that the filings weren't accurate or complete. Raiders have also been known to file suit under 14D when somebody else is trying to acquire stock, right? So maybe there's a couple people that have tender offers out. You want to the best way to make sure that you win is to block somebody else, right? Because if you can block them, maybe you don't have to pay as much. Even if you win, you're going to be paying more. So if you block the other guy, then maybe you can get, maybe you don't have to raise the price. So you know, it's a litigation tactic, or it's a tactic to help you win. And again, a remedy is tell us what you were supposed to tell us, fix your disclosures. All right, so that's the Williams Act. So it requires disclosure if you're amassing shares. Now, you could be amassing shares without making a tender offer, right? You're just buying shares in a corporation. Or you could be planning to make a tender offer. If you are planning to make a tender offer, then you have to file it, disclose that, file it, and whatever. And again, the threshold is 5%. So you'll see people trying to buy just less than 5% without telling anybody, so they can strategize about, okay, when are we going to make this public, and what's the best way to sort of surprise the target company or somebody who may be trying to. And you know, you can imagine where the target company's management is like, hey, we want to take Nordstrom private, right? Whatever, right? We want to take our company private, and so we're going to make a tender offer, and so we file it or whatever. And somebody else in the meantime is like gotten wind of that and started accumulating shares, but they're below that 5% threshold, right? And then all of a sudden, when the one tender offer is made, whoa, there's another one, and you know, and that's how you end up with some of this litigation between folks that are making tender offers. All right, so that's the Williams Act, and I'm getting really tired of talking, so maybe we could pause for a little bit. So next week I will have a summary for you guys of the second half, and I'll probably put it together with the first half, so you've got it all in one place, and we can talk about you know, whatever you would like. And I've been told that you're going to have one essay question, and I have to write 25 multiple choice questions.
Yes.
So you're going to have to answer multiple choice questions. All right. Okay. So, going back, and let's see, was there anything else in here that we wanted to? There's some discussion in the note here about what constitutes a tender offer, and So there are actually two different ways you're going to have to give notice. First is first is the dollar amount, and the other is the percentage, and that's discussed on 922. There's also a discussion about constitutes a tender offer. And remember how I said there was some substantive regulation of tender offers? There's some discussion about that, minimum duration. You have to make the offer open on the same price, same terms to everybody in a particular class of shares, the all holders rule. The best price rule provides that the price paid to any security holder must be equal to the highest price that the bidder pays to any other security holder. So in other words, everybody gets the same price whether you sell early or late in the tender offer. Often tender offers get increased as there's, somebody else gets involved or whatever. So the new higher price must be made retroactive to all the holders who tendered before the increase. If the bidder has made a tender offer, the bidder can't purchase securities that are subject to the tender offer except under the tender offer. That is, the bidder can't make private purchases for a different price. Okay. Williams Act also has withdrawal rights. The shareholder can withdraw tendered but unaccepted shares at any time after 60 days from the date the tender offer was disseminated. So if you've tendered the shares but then change your mind, you can do that after the 60 days. And if you've made an offer for less than 100% of the securities and more securities are tendered during the tender offer than you offered to accept, you must accept all tendered securities up to a stated percentage on a pro rata basis, right? So that was the discussion about what the limits on the substance of tender offers. And Section 14E prohibits material misstatements, including misleading omissions and fraudulent or manipulative acts in connection with a tender offer or solicitation in favor of or opposition to a tender offer. Section 14C is comparable to 10b-5, except it doesn't contain the limiting language in connection with the purchase or sale of securities. So that's in 10b-5. Other elements are connection with, or other elements are similar to 10b-5. You have to establish scienter and so on. Standing, target shareholders have standing to sue under 14d-6, pro rata requirement, 14d-7, the equal under-consideration requirement, and 14e, the anti-fraud requirement, and may sue for injunctive relief under certain under the anti-fraud provision. But a bidder does not have standing to sue for damages. So if you're a bidder, right, even though you end up having to pay more because somebody else violated the Williams Act, you don't get to sue for damages, right? But you can seek an injunction. Okay. Because in theory, an injunction will protect a bidder. Okay, so assessing the response from the target corporation. Unical versus Mesa Petroleum. This is a very famous case, Supreme Court of Delaware, 1985. The point was that pardon me?
I can give the facts.
Oh, yeah, go ahead, please.
Yeah.
Yes.
This is 1985. Mesa Petroleum, the plaintiffs here, owned about 13% of the Unical Corporation. They happen to be the defendants. Mesa submitted a two-tier cash tender offer for 37% of Unical stock at a price of $54 per share. And the securities that Mesa offered were highly subordinated junk bonds. With the assistance of the financial experts involved in the case, Unocal Board of Directors determined that Mesa offer was completely inadequate as the value of Unocal stock on the front end of the sale, which should have been 60 per share, and the junk bonds were worth far less than the 54 per share. And Unocal that adopted a selective exchange offer, whereby Unocal would self-tender its own shares.
Right, so is that out? We'll buy the shares.
And.
But guess who can't? Guess who can't? Guess whose shares we won't buy? Right? We won't buy any shares that are owned by Mesa.
Mesa. So the stockholders, it's $70 a share, I think. And of course, the Unocal board also determined Mesa would be excluded, as we said. The board approved this exclusion because it was Mesa. It was able to tender the Unocal shares, and Unocal would effectively subsidize Mesa's attempts to buy Unocal. And in sum, overall, Unocal board's goal was either to win out Mesa's $54 per share tender offer, or if the Mesa offer was still successful despite the exchange, offer to provide Unocal shareholders that remained with an adequate alternative to accepting junk bonds from Mesa. So Mesa brought suit, challenging Unocal's exchange offer and its exclusion of Mesa shares. And the Delaware Court of Chancery granted actually a preliminary injunction to Mesa in joining Unocal's exchange offer, and Unocal appealed. So the question was whether a board of directors may purchase or repurchase stock from a group of stockholders, excluding others, in order to defeat a threat to the corporation's business. And as long as the board's selection of these stockholders to purchase from it's reasonable in relation to the threat, and it's not motivated primarily for them to take over the corporation. And the court ruled yes. The board of directors may repurchase stock from its stockholders selectively in order to defeat a perceived threat, as long as that selection of which the stockholders to repurchase from is reasonable in relation to the threat and not motivated by the stockholders, by the board of directors' own interest to take control.
Yeah.
Correct?
Yeah. So the Unocal said, hey, Mesa's two-tier offer, right? Cash up front, bonds at the back. They were trying to seek selective treatment for themselves. So the board's approval of the exchange was made in good faith on an informed basis and exercising due care. So it said the directors properly employed this device to protect the company from Mesa's tactics. All right. The Delaware Supreme Court held so start their analysis. Basic principle that corporate directors have a fiduciary to act in the best interest of the stockholders. And the duty of care extends to protecting the corporation and its owners from perceived harm, whether a threat originates from third parties or other shareholders. Powers aren't absolute. Don't have unbridled discretion to defeat a perceived threat by anything. Anything's possible. The restriction on the stock repurchase is that the directors may not have acted solely or primarily out of a desire to keep themselves in office. Of course, a further caveat, the inequitable action may not be taken under the guise of law. Okay, goal is to show that they're actually motivated by good faith, which in all circumstances must be free of fraud. Okay, but that's not the end. Okay, further aspect is the element of balance. If a defensive measure is to come within the business judgment rule, it must be reasonable in relation to the threat posed. So this means the directors of the board They have to know what the takeover bid is and its effect on the corporate enterprise. Some concerns might be inadequate price, the nature and timing of the offer, questions of illegality, the impact on constituencies other than shareholders, creditors, customers, employees, perhaps even the community generally, and the risk of non-consummation and the quality of securities being offered in exchange. And they say, it seems to us the board may reasonably consider the basic stockholder interests at stake, including those of short-term speculators whose actions may have fueled the coercive aspect of the tender offer at the expense of long-term investors. Having the threat posed was viewed by the board as grossly inadequate two-tier coercive tender offer coupled with threats of greenmail. Specifically, the Unical directors concluded that the value of Unical was substantially above that $54 a share, and they determined that the subordinated securities, the back end, right, would squeeze out of the remaining shareholders in the back end merge worth far less than the $54. So the cash part wasn't adequate, and the junk bonds were really inadequate. The court held it's well recognized that those offers are coercive, designed to stampede shareholders, right? Because you want to get the cash, right? Even if the price is inadequate, out of fear that if you don't sell now, you'll get stuck with those crappy junk bonds, right? So it's designed to make you rush to get to the end of the line. And the offer was made by a corporate raider with a national reputation as a greenmailer. Okay, and it tells us what, and conveniently enough tells us what greenmail means. That wasn't one of those terms we talked about before. Greenmail refers to the practice of buying a takeover bidder's stock at a premium that's not available to other shareholders in order to prevent the takeover. In other words, Mace is like, okay, we won't take over Unical, but you got to pay us above the market price, right? So that would be greenmail. And Mesa made tremendous profits from its takeover activities, although in the past few years it has not been successful in acquiring any of the target companies in an unfriendly basis. In other words, they're making takeover attempts, they're making lots of money, and they're not actually taking people over, right? Trial court specifically found that the actions of the Unical board were taken in good faith to eliminate the inadequacies of the tender offer and forestall payment of greenmail. Okay. The board said its objective was to either defeat the offer or, if the offer still succeeded, to provide almost 50%, the 49% of stockholders who would otherwise be forced to accept the junk bonds with $72 worth of senior debt. And the court found that both purposes are valid. Those efforts would have been thwarted if Mesa could have participated. First, Mesa could have tendered shares. Unical would be effectively subsidizing Mesa's effort to buy Unical stock at $54 a share, and Mesa could not, by definition, fit within the class of shareholders being protected from its own coercive and inadequate tender offer. So the court said, selective exchange offer is reasonably related to the threats posed, consistent with the principle that minority stockholders shall receive substantial equivalent of what he had before. This concept of fairness is relevant in the area of tender offer, mergers, but it's relevant in the tender offer. Thus, the board's decision to offer what it determined to be the fair value of the corporation to the 49% of shareholders who would otherwise be forced to accept the highly subordinated junk bonds is reasonable and consistent with the director's duty to ensure that the minority stockholders receive equal value for their shares. So basically, Unical, you were right. Okay. Mesa contends that it's unlawful, trial court agreed for the corporation to discriminate against one shareholder. It argues that no case has ever sanctioned a device that precludes a raider from sharing a benefit available to everybody, but the Supreme Court says the principle of selective stock purchases is either unknown or unauthorized. The only difference is that before was the payment of greenmail to a raider or dissident posing as a threat. All other stockholders were denied such favored treatment, and given Mesa's past history of greenmail, his claims here are rather ironic. In other words, they're claiming, hey, we don't get the benefit by the higher price paid to the other shareholders. Well, yeah, except in the past, what you did was manipulate things so that you got paid a higher price than other shareholders. So, and it's not terribly fair for you to complain about that. Recognizing that as time has evolved, takeover practices have gotten more sophisticated. And so even though this exchange offer is a form of selective treatment, given the nature of the threat, the response is not unlawful, it's not unreasonable. If the board of directors is disinterested, has acted in good faith with due care, its decision in the absence of an abuse of discretion will be upheld as a proper. So the business judgment rule is found to permit making an offer that would exclude a particular shareholder, the one that's that's made the tender offer. All right, so yeah, obviously this was a big deal when it came out, and obviously it was in the middle of the 80s too when this happened. Let's see. And notice that the board brought in investment banks to tell them what they should do, or to advise them. The meeting lasted for 9.5 hours, and then they came back. They considered multiple strategies. That's why the meeting was so long. That's part of why the court found that it was covered by the business judgment rule. The board's got the burden of showing that it did a reasonable investigation and had a reasonable ground to believe the offer posed a threat. And why is that? Because there's a concern that the directors, both inside and outside, are acting to keep their positions and making money and not in the interest of the shareholders. And one of the main points is whatever you do, it needs to be proportional to the threat, or reasonable in as related to the threat that's presented. Okay. All right. Let's take a couple of minutes. Is that starting over again? Was it just like do it?
No, the exam soft. Somehow it picks up something in here and it just turns off and on. It's just
okay.
a few more weeks with exam soft and I'm booting it
And then
up.
you'll never have to worry about it again.
Just for the bar.
Oh yeah, the bar, yeah. Yeah, well, exactly.
Okay, are we all gonna go? What? Watch
Stormy Daniels?
Stormy's new.
Wow, unbelievable.
Stormy went out and asked him right out.
When? Are you sure? Are you serious?
I'm not kidding you at all. I'm not kidding you. It's like Stormy's Secrets. And it's coming out. It's coming out. No pun intended.
What's coming out?
Stormy Daniels is
Stormy
telling it all.
Daniels' new, well, I don't know if it's a tell-all, it's her new
I
video.
guess you're the one
It's
who's
called-
excited about
It's
this.
called.
Nobody
Stormy's-
else seems to be
it's called
excited about
Stormy's-
you.
like, you're just better. It's called Stormy's Secrets. That's what it's called.
I can't
With
wait.
whom?
I don't know.
She's out to make money.
Yeah, absolutely, she is.
The woman's
This
a
just goes-
freaking
this just goes-
prostitute.
this just goes to- Exactly.
She's a
Yes, she is.
prostitute. Why
Yes, she
do
is.
I even listen to?
What's wrong with that? It's gotta be good. Make an honest living. Get down, get down. She'll be wearing her eyes out shirts. Eyes up there, cost. When I was younger, they were called eyes on. Now they're cost. Coast.
Oh, yeah, I wear these to work.
Shirts.
It's easy, just jeans and a
Yep,
t-shirt.
I wear my doctor chinos. She's still ranting about this now?
Stormy
I'm dying, there's too much.
How would we? I'm supposed to.
There's too much, there's fucking too
See,
much.
this corporation shit is loaded. It's supposed to be fresh in our mind. You know what the fuck it is.
Please let me know when you're registering for the PR, because I want to drive up with everything like last time.
It's over here. We're playing our time for that.
In August. I know, it's still.
I think we should do that. There's no way. There's no way.
It's gonna be.
That's what I'm saying. Yeah, so the same ticket must be Saturday.
There's no.
Maybe you understand.
Yeah,
Because I
listen
signed
for
it.
them, I'm nothing to write with.
Somebody.
I need those. Barbie.
They're gone already.
You're just bitter.
I don't want to hear about a freaking porno star. Who has
Well, then, you know what?
cold girl.
Wouldn't have to. Wouldn't have to if you're president.
He did it before he was the president. It was not like your president who did it while in the office. He did it 10 years ago. Who cares?
You know what?
Who cares about blowjob? Who cares?
Who cares? Exactly.
That's what he did, okay? Big deal.
It's only sex.
This is too much to learn in corporations, man.
A lot of stuff.
How are we supposed to know this? Wrong before the law.
Get on it.
Don't you think?
Yep, get on it. It's tough stuff.
We're gonna end up with the
Absolutely.
least, you know, we expect the least, we'll end up with it.
I'm dying.
Come on.
Memories of the way we were.
Are we going to, you guys should have called me to wear red. I would have worn
You
red.
got to get the memo.
I did.
Go to the bar after we get that memo too.
Can we ask Mr. Barry Mack if we could just meet in Palm Desert tomorrow?
Tell me where I will cut and wow, so be there in a second.
Family?
He needs like one of those dental bits, so that's it.
Patrols. Patrolling.
She trying.
Hilda, ask Irene for your invitations.
All right, kids.
Don't forget.
We have okay. Oh, the air conditioner's on. That's good. Okay, so let's talk about poison pills a little bit. Poison pills are things that a takeover target adopts to do what? Try to keep from getting taken over by somebody they don't want to get taken over by. A poison pill, and there's a note on page 939, a poison pill, otherwise less colloquially known as a rights plan or a shareholder's rights plan, is a plan where the board of directors creates rights that are distributed or could be distributed to shareholders, and upon the occurrence of certain events, the shareholders, other than a raider, right? So a bidder, prospective bidder, has the right to purchase stock in the corporation or stock in an acquirer at a deep discount, usually half price. Because the potential exercise of the rights would dramatically dilute the value of the target stock that the bidder proposes to acquire, the mere potential that rights will be exercised may serve as a deterrent to making a bid in the first place. Because it's like, oh yeah, you're going to buy us? Well, we're going to make it like really expensive because you're going to buy stock very additionally a bunch more. The actual mechanics of poison pills are highly complex. They've evolved, and we've got a description here. taken from a Delaware case in 1998. You can read what the description is. It is kind of complicated. A flip over pill is normally triggered only by a corporate combination between a bidder and the target following an initial tender offer. The effect of a flip over pill may therefore be moderated where the bidder's business plan allows it to forego that kind of merger. A flip-in pill is much more wide-ranging, but usually the rights issued under such a pill can be redeemed by the target's board for a nominal consideration at any time before a triggering event, and often for a brief period thereafter. Among public companies, poison pills are ubiquitous. Should the validity of a pill turn on whether a company's board has adopted the pill before there was a contest for control? And there's been some litigation about that. Moran versus Household International held that a corporation's board could adopt a poison pill and do so unilaterally, that is, without the approval of the shareholders. In issuing the shareholder rights, the board invoked the authority which it enjoyed under the so-called blank check authorization under Delaware law and most states to amend the articles of incorporation that contain a provision that empowers the board to issue shares, rights, and privileges and preferences as they may from time to time do it. The court said rights plan isn't absolute. When the board of directors faced with a tender offer and a request to redeem rights, they will not be able to arbitrarily reject the offer. They will be held to the same fiduciary standards that other boards of directors will be held to when deciding to adopt a defensive mechanism. There's little change in the governance structure, and the board does not have unfettered discretion in refusing to redeem the rights. The board has no more discretion in refusing to redeem the rights than it does in enacting a defensive mechanism. Really? Okay. Moran emphasized the redemption provision of the poison pill, saying this is crucial to the pill's validity. What are the benefits of kicking the validity down the road to when there's a contest and the bidder or target tries to fight it? Is there a downside to testing the pill's validity in the heat of a takeover contest? You bet there is. So pills provide important protection against unwanted suitors, and lawyers have been very innovative in their quest to make their clients' pill bulletproof. The dead hand provision of a poison pill is one innovation. It provides that the rights plan cannot be redeemed except by the incumbent directors who adopted the plan or who were their designated successors. The dead hand provision seeks to reduce one obvious route for an unwanted suitor to ultimately overcome the pill, undertaking a successful proxy contest, right? Getting its own people on the board. So if you say, well, that's nice, but the only people that can change that poison pill are the people that put it in place to begin with, that doesn't work. And there's some discussion of, there's a Delaware case that found that it wasn't a dead hand pill. And there was a case from a trial court in Georgia that it was valid. But that was based on another state, on Georgia law. So a sequel to the dead hand pill is the delayed redemption provision, which provides that if a majority of the directors are replaced, the newly elected board cannot redeem the rights for 6 months if the purpose or effect was to facilitate a transaction with an interested person. And again, that got litigated. This delayed redemption provision tends to limit the freedom of the newly elected directors. Therefore, it violates the duty of each director to exercise his or her best judgment. So that was found to be invalid. Shareholders frequently propose declassifying board of directors. Recall that corporations can provide directors can serve staggered 3-year terms, but only 1/3 terms over every year, reflecting on why activists, shareholders are eager that their portfolio companies elect all their directors annually. During a 5-year study period, some professors found that staggered boards increase the likelihood of a company remaining independent from 34% to 61%, and that staggered boards reduce the likelihood of the first bidder being successful from 34% to 14%. So, obviously, you preserve your independence a lot easier if you have a staggered board. So, for whatever that's worth. Okay. Pills. So poison pills have basically 3 features. The trigger, what triggers the poison pill, what sets it off, catastrophic event, and the redemption feature. The trigger is what level of ownership or a bid activates the pill, right? That's expressed as a percentage of ownership. Usually it was 15 to 20. More recently, pills have set it as low as 5%. If the trigger occurs and then the doomsday machine becomes engaged, it can't be stopped. That's called the catastrophic event. Classic versions are the flip and right, which allows the holders the option to convert their shares into short-term promissory notes. One common conversion is for every $100 of value of shares, you get a $200 note. The flip over rights addresses the exchange ratio if there's any merger or other transaction. This also, with the interested party, is also commonly expressed as providing not less than $200 in value in securities for each $100 given up by a target shareholder. Thus, the route to a takeover is to convince the board to redeem the pill. Pills usually provide they can be repurchased by their issuer for some nominal amount, like 5%, 5 cents per right. Know that what the pill does is transform the tender offer mechanism for gaining control into having to be a friendly deal, right? So all of a sudden, if you want to take over, you can't do a hostile takeover. You got to make nice with the current management or the current board. But remember that current management and current board has a fiduciary obligation, especially if the company is up for sale, right, to get the highest price. Okay. Okay, Revlon versus McAndrews, also a really important case. And that is over on page 949. Battle for corporate control of Revlon. Court of Chancery enjoined certain transactions designed to thwart the efforts of a company called Pantry Pride to acquire Revlon. So they sued Revlon, the board, and its Forsman Little, which is its investment bank, and the latter's limited partnership called Forstman. The injunction barred the consummation of an option granted to Forsman to purchase certain Revlon assets. Ooh, sounds like a poison pill, right? The lockup option, a promise by Revlon to deal exclusively with Forsman in the face of a takeover. That's a no-shop provision, right? We talked about that. And the payment of $25 million cancellation fee to Forsman if the transaction was aborted. Court of Chancery found that the directors had breached their duty of care by doing that and effectively ending an active auction for the company. Trial court ruled that those arrangements are not illegal per se under Delaware law, but their use under these circumstances was impermissible. And the Supreme Court of Delaware agreed and affirmed. Okay, there is a very detailed description of what happened. Ronald Perlman, Chairman, Chief Executive Officer of Pantry Pride, met with his counterpart at Revlon, wanted to buy them, friendly deal. Perlman suggested a certain price, and the current management said, no, that's way below what it's really worth. And as it says, All subsequent Pantry Pride overtures were rebuffed, perhaps in part because of Mr. Bergerak's strong personal antipathy to Mr. Perlman. In other words, these guys did not get along. So Pantry Pride authorized Perlman to acquire Revlon, either through negotiations or by making a tender offer, and then meet again, talk about what they might do, and Revlon board met to consider the threat of a hostile bid. At the meeting, Revlon's investment bank advised that $45 a share was grossly inadequate. Some really famous lawyers of Ferris, excuse me, explained, or actually those guys are investment bankers. At Pantry Pride, explained to the board that their financial strategy for acquiring Revlon would be through a junk bond financing followed by a breakup of the company, and Pantry Pride could get a return of $60 to $70 per share, while the sale of the company as a whole would be in the mid $50 range. So offering to buy it for 40 or whatever, that's not nearly what it was worth. Martin Lipton, by the way, famous anti-takeover lawyer, recommends two defensive measures. One, company repurchase 5 million, up to 5 million of its outstanding shares, and adopt a rights plan. Under the plan, the Revlon shareholders would receive as a dividend one note purchase right for each common share, and with the rights entitled the holder to exchange one common share for $65 Revlon note. Okay. At 12% interest was a 1-year maturity. Ouch, that gets expensive. And they become effective whenever anyone required beneficial ownership of 20% or more of Revlon shares, unless the purchaser acquired all the company stock for cash at $65. So basically, they're trying to set the price high enough that they don't think that Pantry Pride is going to be able to pull it off. Then, in addition, the rights wouldn't be available to the acquirer, of course, right? And prior to the 20% triggering event, the board could redeem the rights for 10 cents each. So basically, until it's triggered, we can buy it back, and we're going to exclude Pantry Pride. Okay? Pantry Pride says, oh yeah, we're going to try to buy you, makes an offer, and Revlon board meets again. The directors say, hey, shareholders, reject this. More defensive measures, right?
And that's where the role and responsibility of the board changed, is it not? Pantry Pride continued to raise the amount in the offer.
Yeah. So Revlon does its own offer. Okay, now what's the option? Now that the company is for sale and it's only a question of who's going to buy it, what happens, right? And the point is,
right.
now it's not the board saying, well, we're trying to protect shareholder value. The only way now that the company's up for sale to protect shareholder value is what? Get the highest price. Okay. So Revlon's got its own offer, common stock 10 for 1 for a note at a certain price with 11% interest, and some additional convertible shares, et cetera, et cetera. And so now Pantry Pride is like stuck. They can't do the takeover. And then Pantry Pride announced a new tender offer, $42 a share conditioned upon receiving 90% of the outstanding stock, and it would consider buying less than 90% at an increased price if Revlon removed the poison pill. It was lower than the initial proposal. Revlon's investment banker described the two bids as essentially equal in view of the completed exchange offer. Okay. Revlon has a meeting. Directors reject the offer. Authorize management to negotiate with other parties. Pantry Pride remain determined and continue to make cash bids for the company, offering $50 a share, then $53 a share, and then $56 a quarter. In the meantime, Revlon negotiated with Ted Forsman and another investment firm. Directors met to consider the pantry pride grid and possible alternatives. So it sounds like they're trying to get the highest price, right? The directors agreed to a leveraged buyout by Forsman, 56 a share. Oh, wait a minute, that's a little less than that 56.25. Management would repurchase the stock in the new company by exercise of their golden parachutes. Forsman would assume Revlon's debt, and Revlon would redeem the rights and waive the notes covenants for Forsman, or in connection with an offer that's superior to Forsman's. Board didn't actually remove the covenants because Forsman lacked a firm commitment on its financing. Then when they announced the merger, market value of the securities began to fall. The notes, which were traded around 100, dropped to 87.50. And there was a deluge of phone calls from irate note holders. Pantry Pride then comes up with a new offer, right? 56.25. Nullification of the rights, waiver of the notes, covenants, and election of its own directors. Pantry Pride, Revlon, and Forsman negotiate or meet and attempt to negotiate the company. Couldn't reach an agreement. Pantry Pride announced it would engage in fractional bidding and top any Forsman offer by a slightly higher one. And Forsman had been made privy to certain Revlon financial data, so they're playing favorites, giving Ted Forsman information that Pantry Pride didn't have. With that information, Forsman meets with special counsel, makes a new 57.25 offer with some conditions, and so on and so on. And Pantry Pride had originally sought injunctive relief, filed a amended complaint, challenged the lockup, cancellation fee, and the exercise of the rights and notes covenants, and also sought a temporary restraining order to prevent Revlon from placing any assets in escrow or transferring to Forsman. And again raised its offer. Chancery prohibited further transfer of assets, and then enjoined the lockup, the no shop, and the cancellation provision, all those poison pills, right? And the trial court concluded Revlon directors had breached their duty of loyalty, right? By making concessions to Forsman out of concern for liability of the note holders rather than maximizing the sale price. And then we talked about probability of success on the merits and all of that. And they go through item by item, okay? First one, first defensive measure, we give all the shareholders right to be bought out at a substantial premium. Board clearly had the power to adopt the measure. So the focus is, was it reasonable? The reasonableness and what its purpose was. To the extent the board acted in good faith upon a reasonable investigation, under the circumstances, it can't be said that the rights plan was employed was unreasonable, considering the threat posed. The plan was a factor in causing Pantry Pride to raise its bid from a low of 42, eventually to 58. And at the time of its adoption, the right plan afforded some protection consistent with the director's fiduciary duty, cites Unical. So it wasn't a showstopper, as the plaintiffs had contended in Marine. It's spurred bidding, right? So actually, okay, so far so good. But as things developed, that rendered its continued usefulness was going to be removed by what the directors did on October 3 and October 12. The board redeemed the rights conditioned upon the consummation of a merger with Forsman, but acknowledged they would also be redeemed to facilitate a more favorable offer. Board unanimously passed a resolution redeeming the rights with any cash offer above 57.25 or more. Because all of the pertinent offers eventually equaled or surpassed that amount, the rights clearly were no longer any impediment. So this mooted any question of their propriety. Okay, so rights plan, okay, right? Mm-hmm. Second was the the company's offer to exchange for 10 million of its shares. Directors had the power to do this, right? But when exercising that power in an effort to forestall hostile takeover, the board's actions are strictly held to a fiduciary standard set forth in Unical, best interest of the corporation and its stockholders, and imposed an enhanced duty not to do anything that's motivated by considerations other than good faith concern for those interests. They concluded that offer was inadequate, so they acted in good faith on an informed basis. So the adoption of that defensive measure was reasonable in relation to the threat posed, so that's proper. But when Patriot Pride increased its offer to $50 a share, then 53, the breakup, then it's clear now we're going to be selling the company, right?
Right.
And so the board permitting management to negotiate a merger or buyout was a recognition the company's for sale. Then the duty changed from preservation of Revlon as a corporate entity to maximization of the company's value for sale, right?
Mm-hmm.
That altered the board's responsibilities. Under Unical, now it no longer faced threats to corporate policy or effectiveness or to the shareholders' interest from an inadequate bid. The whole question of defensive measures became moot. The director's role changed from defenders of the corporate bastion to auctioneers charged with getting the highest price. That's a huge, huge, huge change, right?
Yes.
So now we come to the lockup enforcement and shoring up the sagging market value of the notes. Original threat, breakup of the company, had become a reality, which everybody recognized. Selective dealing to fend off a hostile but determined bidder is no longer a proper objective. Okay, now it's trying to get the highest price. So the board cannot make the requisite showing of good faith by preferring the note holders and ignoring its duty of loyalty to the shareholders. The rights of the former already were fixed by contract. In other words, the note holders were going to get paid. They didn't require any further protection. And so when Revlon entered into an auction block lockup agreement with Forsman, it was not looking out for the shareholders, and they breached their duty of loyalty to the board. Okay. The court rejected the argument that they had a good faith obligation to the bondholders. Those are limited to the principle that one may not interfere with contractual relationship by improper actions. The note holders were fixed. They had fixed rights, so we're going to get paid back. And there's nothing in substance to suggest any of those terms were violated. The notes covenants specifically contemplated a waiver to permit the sale of the company at a fair price. The notes were accepted on that basis. Okay, so now a lockup isn't per se illegal. It's been approved. The lockup provision might sometimes be legal, but those which draw bidders into the battle benefit shareholders, and similar measures which end an active auction foreclose further bidding is to the shareholders' detriment. So that lockup with Forsman foreclosed future bidding and thus hurt the shareholders, right?
Mm-hmm.
The Forsman option had a destructive effect on the auction process. Forsman had already been drawn into a contest on a preferred basis, so the result of the lockup didn't foster more bidding, but destroyed it. The board stated reasons were better financing, no holder protection, and a higher price, but the Chancery Court found that any distinctions between the bids or the method of financing were nominal, and the considerations had little or no significance. The principal object was really to protect the note holders over the shareholders' interests, which wasn't proper, as we've seen. The margin of superiority of the Forsman bid was less when the price was adjusted for the time value of money. Revlon ended the auction in return for very little actual improvement in the final bid. The principal benefit went to the directors, who avoided personal liability to the class of creditors to whom the board owed no further duty. Thus, when a board ends an intense bidding contest on an insubstantial basis, and where a significant byproduct is to protect the directors, then guess what? Then it doesn't meet scrutiny. Okay. In addition to the lockout provision, the Court of Chancery enjoined the no shop provision. That provision wasn't per se illegal, but it's impermissible here when the board's primary duty becomes that of an auctioneer responsible for selling the company. The agreement to negotiate only with Forsman ended rather than intensified the investment in the bidding contest. And they point out it's kind of ironic that they had the no bid thing when they've been favoring Forsman all along. You can see what happens. The board can do things if its goal is to protect the company from an inadequate tender offer. But once it becomes clear that the company is up for sale, then it's how do you get the best price? Are you guys trying to tell me that we need to go? They're giving me the cut sign here. It's 8 o'clock. What?
They wanna go home probably.
Oh, they want to go home
Okay.
probably.
Are you telling me that,
You're the last one standing.
We're always the last
No,
one
that's okay. These guys are studying. Take your time. Do whatever you need. We're just
Okay.
teasing.
well, we're talking about poison pills here. Okay, so, this is,
They really wanna go
When
home.
Irene starts married, and she has the.
oh yeah, because Irene's usually like, hey, you guys gotta go tonight.
Exactly.
Right, so poison pills, right? They are a double-edged sword, because on the one hand, they can be perfectly appropriate if what you're trying to do is protect the company from a bidder who's trying to lowball and, like Perlman was trying to get the company cheap. But once you turn into we're just trying to sell it for the highest price, if they impede you getting the highest price, then you can't use them. And here, it was clear that one of the reasons that they were doing this was to try to protect the directors from what? From liability to the note holders, which wasn't protecting the shareholders, wasn't protecting the corporation, was protecting the directors. That's an improper proof.
And it was very apparent in front end when
Absolutely.
they were filling the poison pills.
Yeah, this is amazing
Very
amount of
apparent.
information to digest like last minute. Oh my
Yeah.
God. I'm like freaking out how much there is to learn.
Yeah, so
Or even for Barbara, but we'd be hitting the bar in July and we'd be taking it in February.
We're taking,
also.
what Judge Hoffman can tell you, we take his first test on Saturday, and we take the second half of the test on Sunday, and the third half of the test on.
yeah.
The bar.
Third half.
The third half, right? You get it? No, guys.
Okay, well, you know what? I think we probably covered enough that for tonight. So, use this to prepare for the final and maybe for the bar exam, because it does talk about.
That's already exhausted here as well. so-
Yeah.
And the other one, I like the other one. you
So it
gave us.
discusses a bunch of
I
different
like the
stuff.
insider trading you gave us.
Right, I like that.
So it summarizes a bunch of stuff, and
You're gonna give us the summary.
I gotta go write something.
If you get it done, please email it to us. We'll get started on that right
Yeah,
now.
well, I gotta do your exam first.
I like this.
Okay.
You're doing one exam or two?
25 multiple choice and one essay.
Oh, good.
That's what I have been directed to do.
Good, good.
So
We shall survive.
it's been lots of fun working with you guys this semester. I know we got one more class.
You've been awesome.
I've enjoyed it a
Great
great deal.
Yes, indeed.
And I've tried to focus on a lot of the policy stuff and why do we do stuff, and not so much on the particular rules, because you can learn the particular rules.
Yes.
But trying to focus on the why and what's Congress trying to do and whatnot.
I enjoyed it.
Anyway, so we'll see you next week.
All right, thank you so much.
And Hilda, I hope your
For horsey.
horse is okay. I'm really worried about that. What's he got?
Well, they don't know. Either it's a neurological condition of some sort, most likely they're gonna put him down, or he injured his back because they gave him the beach and all of a sudden he's running around and
Yeah.
But within seconds, it was galloping. He's an older horse.
Yeah.
But I don't know, he was bumping his head a lot when I was hugging him.
Well, that sounds a little nervous.
That means he's a little bit in distress and pain.
Yeah.
So we're gonna give the painkillers for a week, see what happens. But I
Yeah.
get the peace in his last night.
Yeah, I'm sorry. How old is he?
30, he's gonna be
Okay,
30.
yeah, he's-
He had a very good life.
That's not sure.
Yeah, he's gonna be 30. I bought him when he was 24. He was 4. I
Yeah.
had him for
Oh my
26.
gosh,
He was a
that's
baby
a
when
long
I got
time.
him, yeah.
Yeah.
Yeah, he's had a long, good life, no doubt.
My mom, my grandparents had a horse who they bred, and then she had a son, or male, right, who was my mom's horse. Well, then my mom goes off to college and then, never comes home. And Lee had the